The Honorable retired Supreme Court judge has been put to notice, my lord, that the stadium was already attached on 6/10/2022 in EP 1 of 21. Even thereafter, my lord, matches were held in the stadium. As a person who was involved in the HCA at earlier point of time, and as my clients also, that is the managing director also loved the sport, we did not meddle with the matter. We'll still caution them that you are acting in violation of the attachment orders which are subsisting. Thereafter also, after 6/10/22, they did not pay the money. We went on insisting before the commercial court to take up OP 83 of 2016. My lord, the gentlemen do not appear before the court. The commercial court, City Civil Court Hyderabad, put them to notice thrice. Still they did not appear. Conditional orders were passed. It is thereafter that he dismissed the section 34 OP in default. They have filed an application for restoration of that OP, which was argued day before yesterday. By evening, my lord, the arguments were submitted. We have made our submission before the commercial court that there has been no stay in this matter throughout. Still, we held our hands because we also love the sport. Now, my lord, ultimately, we are also citizens. Our rights cannot be trampled upon just because a person at a higher place. My lord, we have to utmost respect for the single member committee appointed. But that doesn't mean, my lord, that anybody is above law. The lordship may also kindly see we filed EP 12 before the concerned court for attaching their bank account. Because though there is no stay, though they have been put to notice, though the stadium is attached in October 22, they don't pay. They don't argue the section 34 petition, they don't care as to the pendency of the proceedings. The lordship may kindly see it is thereafter that the bank account attachment orders were passed. Now, your lordship may also kindly see, as far as EP 12 is concerned, my lord, your lordship sees the COP 83 of 23 was dismissed on 14 July 23. Your lordship,
Yes. 14
July 23. Well, lord, we waited for 1.5 months. We filed the EP 12, well, lord, by the end of August, 31st of August. Notice was ordered to HCA. They appeared on 12th September for this account attachment. From 12th September on, the request matter was posted to 14th September. From 14th September to 19th September. 19th September, they filed an adjournment application. Well, the commercial court put them to notice that, see, the commercial court acts has a certain schedule, even for taking up the original proceedings. Well, lordship, I kindly see on 19th September, the adjournment filed by them was allowed with 1,000 rupees cost, directing them to file their counter by 22nd September. And it is thereafter, on 22nd September at 4:30, the order was passed. Lordship may kindly see that ultimately, any howsoever high I may be. Lord,
no question of howsoever. We are examining the validity of the order dated 22/9, not determining the status of the parties. 22nd September 23 order. Now, why we always thought, we know that you are under a pressure to argue, but the fact remains a petition under section 34 has been dismissed for default. Argument on restoration have been heard. Order is expected any moment, like it can be passed. What way, with your experience, you know what could be the order?
There is another angle to it. Your lordship may kindly appreciate.
Until unless, I mean, something otherwise. Ordinarily, what do we do? We dismiss your cases for default. When you come up, what do we do ordinarily?
Well, I'm conscious and aware. Lordship may kindly hear me for a moment.
We will put them to terms, like that is understandable. 34, they should argue. You can't be asked to wait indefinitely. That is all understandable.
I'm not depending on that dismissal in default. The lordship may kindly permit me to explain.
Yes.
Lordship sees.
This is admission, right?
No,
admission. He also like passing a list of dates as if final hearing is taking place. We don't.
What I'm trying to say,
yes.
Maybe lordship would get.
So you tell us why stay should not be granted.
Permit me. Lordship says execution is not because of dismissal in default. Lordship may kindly appreciate we are dealing with a commercial court matter, and awards are entitled to execute if there is no stay obtained. Stay was not obtained for the last 7 years, from 2016 till 2023. Dismissal in default is an incidental matter which I am bringing to the notice of the Honorable Court. In fact, what we argued day before yesterday, I put it before the lordship. before the commercial court. We told the commercial court specifically that, my lord, if the applicant, we are not standing in the way. If the application has to be allowed, let them be put to condition. Lordship knows that when a stay order is passed in a 34 application, parties will be directed to deposit at least 3/4 of the amount, if not full amount, my lord, which is the award of, with accrued interest thereof. Now the learned commercial court heard us and he said, I will consider it. That it is at that stage of my.
Oh, we understand that they can be put to terms.
Wait, my lord.
Yes, correct.
7 years.
Yeah.
I did not withdraw.
All right. Yes, 1 minute. Yes, Mr.
Millets,
How much amount will you deposit?
millets may say
In the proceeding under section 34 for 7 years, there is no stay.
may
And
put it,
therefore, he has filed an execution petition and there is a money decree. This thing, how much amount will you pay?
may put it this way, millet. Millet, 4 weeks from today may be granted, millet, as my lord says so, millet. And the quantum of the award that has been passed, millet, that will be deposited by November 15, millet. Till such time there may not be any garnish order or attachment order and seizure of the stadium prohibiting the players today. They are there on the ground, millet, that the mobiles have been shifted away.
No, but that order of attachment is not before us.
Exactly, millet.
It's not before.
Millet, that's what the council was making a reference that CRP is made. Now, millet, the court bailiff is in the process of shifting the whole of the mobiles and the players are there in the ground.
So how much will you pay?
Millet may say so, millet, 50%, which is the normal norm after 4 weeks, millet.
16, your lordship may kindly see the
Correct.
calculation. If
After 4 weeks, millet.
Page 16,
You know 50% is the usual.
asking for more, your lordship may kindly see. Page 16, the
So
calculation.
this is for admission, Mr. We will hear you at length. You file counter.
No, just a second, my lord. My lord, the award amount is 25 crores 92 lakhs. EP amount is 61 crores 22 lakhs. Let them deposit half of the EP amount and pass.
Millet, decretal amount, I said, millet. Award of decretal amount for 6 weeks, millet, may say that we deposit, millet. Millet, that statement is this, millet. Millet, the present functioning is the interim functioning, millet, which time we will clear the election process, file the report, and as it is, the revenues would be there in the bank and it will not be released to any other private party subsequent to the report. That's what I can say so, millet. Millet, that's the reason I'm saying, millet, looking at the practical difficulty of the single member committee to discharge 2 functions. Till 12/10, millet, there are 3 World Cup matches, millet, and election would become, notification is being issued within a week. Millet, notification from the date of notification, 30 days need to be given, millet. Millet, single member committee do not want to hold on to this issue for long.
Coming in the way of the election, my lord. Lordship, this is unreasonable.
Millet, this is,
We are not saying anything about.
He is concerned with his money. You give him money, he
that's
will
what
go.
it is, millet.
My lord, I waited for
You know.
7 years. I waited for 6 weeks.
He will go. That's what he's saying. You pay.
This is so, millet.
61 crores 22 lakhs, my lord. Half of that amount, let them deposit.
All right. Yes. So how much amount will you pay?
Millet,
Your figure. We will decide. That's a different thing.
millet, I
Page
said,
16 calculation is there, your lordship.
You told us 61 crores.
61 crores 22 lakhs 52,925.
22 lakhs, 52,000. 52,000.
925.
920.
Every rupee is important for.
Yes, of course.
I have to put it to give it.
Of course. Yes.
the decretal awarded amount is 25 crores, millet. In that, millet, that would be deposited, 50% would be millet. There is no loss, millet. The penal interest is calculating and accruing every day at 18%, millet. Millet, it is only to facilitate that single member to deposit that money within 6 weeks.
All right. Yes.
18 is not penal.
Heard on the question of admission.
Contracts for the amount.
Yes. Heard on the question of admission. Let them first deposit. Yes, this is on caveat. Very good performance on caveat. We are giving you for let them first deposit, then comes the application.
Your lordship direction, I'm sure now they will follow that.
Yes,
Therefore, I'm saying.
let them deposit. That's what we are saying. You
Very well.
heard on IA 1 of 23, right? Dispensing. Or for the reasons assigned in the beginning, you write IA is allowed. Yes. Next.
May I request,
Ah. Huh?
order copy today itself, my lord, to
Copy today. Yes.
oblige, my lord.
Counsel for appellate, your lordship, short pass over may be given.
Huh?
Pass over, short pass over. My counsel is held in second court.
You are also counsel, right? Not a counsel.
Counsel for appellant,
So who are you?
Mohammed Ismail.
Huh? Who are you, madam? You are also a counsel, right?
Yes.
You tell us. Don't. Nobody is asking you. You sit down. Yes.
Senior is held in second court, your lordship.
What is the case about, madam?
Writ petition.
Writ petition, writ appeal.
Oh.
What has learned single judge done? Pass on. Don't appear like this in the court, right?
Instead of password, kindly have it Monday minute. Instead of password, kindly have done.
Monday? What? Yes, madam, Monday. But you are on caveat.
Respond.
Caveat, no?
Respond.
No, not on caveat, right? Have you filed caveat? I mean, matter is yet to be admitted. We don't.
All these matters not, we had a,
No, we know that advance copy is supplied, but
no, not only that.
and they appear.
No, under the rules of practice here, the writ appeal, we don't need to file a caveat. That's what we wanted to bring to your lordship's notice.
No.
We had a discussion among our colleagues.
No. There is which rule?
Under the appellate side rules, rule 22. And then our wakalat that we file along with the writ petition, empowers us.
Continues.
That continues even in a writ appeal.
But what we are trying to tell him is that the admission is a matter between appellant and the court. Even if he is on caveat, all he can oppose is
The interim order.
So he is seeking, the other person has no idea about the case, right? The counsellor doesn't know what is, whether it's a writ appeal or a writ petition. He is seeking that it is, this is peculiar situation for us.
Wanted to place it before the.
Yes, madam, Monday. Not Monday, Tuesday. Learned counsel for the petitioner prays for adjournment. Appellant prays for adjournment. List on Monday is what it. Yes. This will be issue notice. Listed. None for the appellant records. Heard on IA 1 of 23 and 2 of 23 issue notice. Next.
That's I am appealing.
Notice.
Only one aspect.
Notice.
Seeking interim order.
Notice on IA.
IA1 is for a delay of 151 days. IA2 is my suspension application.
Tell him we have issued notice.
We have issued notice.
I am on record, your lordship. Respondents 1 to 6, I am on record, your lordship.
And what, there are only 6 respondents?
Yes, other respondents also.
So notice of 1 and 6 is accepted by Mr. So and so. Issue notice to remaining respondents.
But respondents 1 to 4 are the aggrieved parties, your lordship. Other respondents, they are in.
We don't know. Yes, notice. Yes. Which item 4? 1 minute. 1 minute. She's calling 4 now. Yes. Call.
Lordship, may I please, Lordship?
Notice on IA number 1 of 23. 3 of 23, then 2 of 23 in the beginning requirement of service of notices. Reasons assigned, you know.
in this.
You accept notice?
I accept notice for respondents. Respondent
Notice on behalf of so and so is it. All respondents, madam?
petitioners, petitioners and WP, my lord, want to.
You should tell us which respondents. That also we have to find out for whom you are appearing, right?
1 to 7, apologies, my lord, 1 to 7. All 1 to 7.
Respondents is accepted by madam, whatever right.
May I say, my lord? May I say, my lord, in this matter, my lord,
Give madam, yes.
the petitioners, my lord, they claimed 15 acres of the land, my lord. Lord, unfortunately, impugned order says that the, Lord, the contrary to
There is nothing unfortunate.
Lord, the 23 acres, Lord, the order is granted. Though the petitioner restricted, the application itself is for the 10 minutes, Lord, I take to the Lord, the page number 26, Lord, the operating portion of the order, Lord.
We have issued notice that very purpose, right?
Lord, otherwise, it's very difficult to hold the position, Lord. It's a 1951 notified forest, Lord. Under the garb of this, Lord, the orders of this honorable, Lord, they are trying to interfere. Criminal case for trespass is also.
Heard on the question of admission, appeal is admitted for hearing, notice on behalf of accepted so and so. In the meanwhile, parties are directed to maintain status quo as it exists today with regard to possession in respect of land inquiry. Yes.
This petition is filed against the order passed by the Honorable DRAT Calcutta, setting aside the order passed by the DRT.
All right, heard on the question of admission. Application is admitted for hearing, issue notice. Heard on IA 1 of 23, issue notice. Yes.
Please, your lordship. It's the matter that the petitioner before your lordship is the student applied for the MBBS course blood on the.
What is the prayer, senior counsel, will you tell us?
Prayer, Millard, is that?
Prayer is to provide reservation for sports quota.
No, Millard,
Can we do it?
I submit your lordship. May kindly see, a GO was issued in 2017.
No, so the case is that earlier there was a promotion for provision for reservation of sports quota that has now been deleted.
Subsequent to the commencement of the counseling,
Deleted.
the notification was issued on 6/3. 6/4 is the last date for submission of application.
But why this belated challenge on 25th September?
They uploaded it lately in the website. Just before, your lordship may kindly see in July.
But rules were amended when? Rules were amended, right?
July.
July.
They issued the GO, but uploaded in August. The difference.
Will issue notice on the question of admission.
Your lordship may kindly, is it a matter of
No interim order.
legitimate expectation?
Nothing no legitimate, we will dismiss the petition, mister. What legitimate? You want an order right away, we will pass.
No, not order.
Okay, yes, please argue.
Indulgence of the.
Please argue. NCC quota. Yes, yes, mister. Please argue.
If they give a wrong impression, only.
No, please argue.
Earlier,
Please argue on admission, we will decide it. You should have, we thought that you will go through our NCC judgment, similar provision that
Your lordship, I
we will.
will post along with that, Millard, I will go through it.
There is nothing that is decided. It is
Your lordship may kindly see.
Please argue. Yes, what is?
No.
You are a participant in which MBBS course, NEET, NEET UG examination. You appeared, right?
Yes, sir.
So 2017 rules, which rule provided reservation of?
17, Millard, your lordship may kindly see. Page 12 starts, Millard, comments.
Page 12.
Yes, ma'am. Relevant page is 17, Millard.
Yes, notification. Yes.
Roman para, page 17, Roman para.
Page 17.
Small e. Caption.
Small e.
Yes. Reservation for special categories. Differently abled candidate, each category 3%. Like sports comes at 3.
1. Rule 3. Yes. Rule 4. 1.5% reservation, right?
No, no,
Mr.
it is a half percentage, 0.5, 0.5.
Ah, wait, 1.5 means same 0.5%.
Yes, sir. I'm sorry.
Now, yes,
Now, my lord, the GO, present GO is issued page 23, my lord.
23. Yes.
This is 4723, my lord. Page 25, my lord.
Yes. Yes.
Sub-rule 5, for class E, the following shall be substituted
Page
name, my lord.
25. Page
My lord, 25.
25.
Yes.
Ah, yes.
Page 25, my lord. Captions, C, my lord. Sub-rule. For class E, the following shall be reservations for special categories, persons with disabilities, CAP.
It has been deleted, right?
Deleted, exactly.
Ah, yes.
My limited grievance, your lords may kindly
Ah.
consider my limited grievance is that
Ah. So how this provision is arbitrary? And how can we strike the?
on the ground of arbitrary manner. This may be my respective submission to your lords, that is the prospective, not applicable to the project admission. This is only my respective submission to your lordship. Look, the notification is issued 6th March. The last date of submission is 6/4 April 2023, my lord. And 7/5, interest was conducted.
Prospective in nature.
This is only my,
Or
sport is a blood, genuinely blood in rifle shooting. He has got award national level.
this.
RMC blood, rifle shooting blood. Was a meritorious student and got blood even admission in the Rashtriya Military College. But his only grievance is that blood, there are seats. I am told that seats are available. Blood. But hoping that he may get a seat, he left the blood. He did not opt the seat in the military college.
All right. Yes. That's it. Anything else?
It's only my.
All right. In this writ petition, the petitioner who heard on the court mark his presence, learned senior
Made page note.
All right, heard on the question of admission, admitted, issue notice. Yes. Notice on IA 1 of 23 also. Whosoever is accepting, they are not saying anything, so we are not.
Then suppose
I take notice for 1 to 3.
Please say so. Madam, write 1 to 3.
I am appearing for 6 respond.
6. Issue notice to remaining respondents. Yes.
after 2 weeks.
Not 2 weeks. Then,
4 weeks.
you want also an order on merits, we will pass. See, no problem.
I kept on edit argument.
No question of not doing, Mr. What happens when we examine the things in detail, right? The things become obvious. So we were suddenly reminded because senior counsel insisted that I will argue ex parte, this relief should be granted. We were reminded that it is covered by our NCC judgment. So
I didn't argue.
no, it's not that you shouldn't argue.
No point in arguing when it's already laid and
Yes. So what about this 7 and 8?
But I attributed all of rights against them.
Which paragraph?
But
Malafide means, Mr. One thing, you are a sufficiently experienced person. You must be understanding the difference between malice in law and malice in fact. What is this case? Malice in fact, malice in law.
both malice in law and malice in fact.
You
Then
please examine.
allegations also. Main allegation against the.
What is the distinction between malice in law and malice in fact? Tell us. Case law.
Malice in law without including
There are decisions of Supreme Court, Mr.
Yes.
You examine this.
But office that your lordship can decide whether there is malice in law, malice in fact.
That's why we are asking you to.
Because of higher authority is implicated, office cannot make objection. Suppose
No, this Mr. Every this thing in such a case, every virus provision is you will impede the constitutional functionaries. So challenge to this understandable. But this thing we want to understand. You have said that this thing.
39.
So
39 onward.
what are these? This thing.
My allegation is
Not allegation. Anybody can that somebody has committed theft. Also, you can write in that this the allegation. Not. So you explain to us. We will decide this question.
yes.
The other option is there are two options. Either you delete their name and we will hear you on admission because validity of rule is under challenge. Second option is you satisfy us that whether it's a case of malice in fact and malice in law and how they are necessary parties for adjudication of the list. In that case, we will pass an order on whether 7 and 8 should be pleaded or not in their personal capacity. Right?
Yes.
So which second option?
Yes.
Learned counsel for the petitioner. How much time do you want?
But Monday, Tuesday.
Not so. What is the urgency? Nothing.
Yes.
Learned counsel for the petitioner prays for adjournment to enable.
For the respondent in this matter.
Your Lordships, Senior Counsel Vivek Reddy was appearing for the appellants. He has a personal difficulty today. If you could please.
One last occasion it was you were not available, so Article 14.
Yes, sir.
We can't violate. She is as a matter of right, and we are not in a hurry in this case. These people are in a hurry.
Not opposed. Okay.
This appeal, yes, mark the presence, madam. Mark the presence. This appeal.
The matter was decided by the commercial court judge.
It is under Commercial Courts Act.
This suit was filed for a
Commercial Court. Appeal under section 13, Mr. What? This appeal under section 13(1)(a) of the Commercial Courts Act 2015 has been.
May it please your lordship. Present on a virtual note, my lord.
Yes, yes.
My lord, this present application is by file questioning the qualification prescribed for the notification for the post of physical director in intermediate education, my lord. The qualification prescribed is one PG along with the PG, one master degree, my lord. Page number 22 is the impugned postcode, my lord.
No. This GO was issued on 25/11/2022.
No, that is not 22, my lord. Mistakenly it is written as 22. That is
11
2002,
months.
my lord.
What is the stage?
2002, my lord. That is 79.
No. The notification. The process commenced on 28/12/2022. What is the stage of the process?
My instructions are that still the examination is not been conducted, my lord. Still it is under pending. The examination which ought to have been conducted in the last month.
You applied for the post of physical director, or you can't apply?
Yes, my lord. Physical director in intermediate education, my lord. The qualification which has been prescribed over here is that is under challenge over here, my lord.
It is for the authority to prescribe qualification. What ground you can challenge?
My lord, the difficulty that the ground on which I am challenging is that, my lord, page 58 to 78 is page 50 to 57, my lord, the NCTA rules, my lord, the NCTA regulations, my lord, National Council teachers, that is page 50 to 57.
Which is the qualification in the NCT?
NCTA is the page 57, my lord.
57. Yes. Where which? Yes.
That is column number 3, my lord.
Column number?
3, page 57.
Serial number 3.
Yes, my lord.
Secondary school.
Yes, my lord. Secondary school immediate for classes 11 to 12. Bachelor of Physical Education BPED or Bachelor of Physical Entrance BPE or Bachelor of Science BSc in Health and Physical Education and degree in sports.
This is senior secondary. This is what?
Intermediate level.
Senior secondary level.
Yes, intermediate education. Now the notification is also prescribed for the sake of this intermediate, my lord. Physical director and intermediate.
No. So where is this post of physical director mentioned that this is the qualification for physical director?
That is at page.
That is what is relevant, right? You are telling.
Yes, my lord, I'll show it.
This is for physical education teachers.
Sir, please refer to
Physical education teacher. Page 57. Ask him. Yes,
madam. Please go to page 56. Refer to the second schedule.
Yes, madam.
This is for the purpose of recruiting physical education teachers in primary, upper primary, secondary, or intermediate schools.
Yes. Physical education teacher and physical director, same. Where from have you got it?
But it is thing is that, my lord, that would be coming.
You understand, right? Page 56 you have seen.
Yes,
second schedule. Second line, physical education teacher.
Yes, my lord.
This post is physical director.
Physical director.
So what is it the one and the same?
Yes, my lord, physical, related to physical.
This is just like saying like this, Mister. You don't examine when you draft the petition. When the court puts a question, then you will say, yes, it is the same.
My lord, with respect to this connected matters which have been filed before this honorable court, my lord, which is at page number 101, the batch of matters which have been filed in this particular issue, my lord. Page 101, the issue, writ petition starts, my lord.
No, you are arguing the case here as if you are the first person. Now we have put the question. You are coming to, we don't know what are the case. You produce copy of the writ petition.
Yes, my lord.
Sir, you understand our query is simple. This NCTE prescribes a schedule for physical education teacher.
Yes, my lord.
Right? Qualification. And this is physical something director.
Yes, my lord.
Whether it is one in the same, that is one thing you have to answer by producing documents. And second is, let's see, in any case, what is the qualification in the state rules?
Yes, my lord. And one more thing, my lord, page 79.
No, contravention is, Mr. It is open for the state government to provide a higher qualification.
Yes, my lord.
This is the issue has been settled by Supreme Court. You don't this has been settled by Supreme Court. Right? You haven't got it, it appears you have not gone through it. So what is the qualification? It is impugned rule.
Master degree.
Which page, Mr.?
Page 22, my lord. The impugned postcode is
22. What does it say?
It's the serial number 2, my lord. Postcode 2.
22.
Yes, my lord. It's a must possess postgraduate degree, MA/MSc/MCom with master degree in physical education with not less than 50% of marks from a university in India established or incorporated or by so and so. Two degrees which are been inflicted over here. One is postgraduate degree and the other is master degree in physical education. So this is master degree.
It is open for the state to provide higher qualification. Yes. Give that NCTE judgment. All right. Anything else?
No, my lord. The only thing is that, my lord, the other connecting matters are pending, my lord. It may be tagged along with that, my lord.
What? You answer.
My lord,
Physical director is saying that the physical director only. All right, list for when a query was put, following queries were put to Learned Council for the petitioner. Number 1, whether the post of accepted by what?
Division bench, my lord, was pleased to suspend, my lord, the interim order by passing interim order in this appeal.
Yes.
My lord, the writ petitioner
Not to argue afresh, we have heard whatever doubts. Docket sheet, every docket sheet in the WA 111117. Where is the order docket sheet? Really, the written is there. 648. Ah. That's not matter.
Yes, sir. Already there was an interim order passed on 7/9/2007, wherein this court has admitted the appeal, stating that police protection cannot be given. In view of the same, the writ appeals have to be allowed.
Yes.
And you also made the extensive submissions that was also recorded in the order. So in view of the same, we are allowing the appeals following the order.
May I request your lords?
Yes.
I rely upon the judgments of this honorable court and following.
No, you can argue, Mr. Rao, whatever, some doubt was there, because this interim order we did not notice, therefore we had listed the case.
No, you
can argue whatever.
My respectable submission, your lordship.
Yes.
The state was contending that the land in survey number 116/2 and 116/3 was a form of land. And contrary to the records, they have filed a LGC 10 of 2000. Your lordship, that was dismissed by the special court, holding that the respondent in this writ appeal is the owner of the property. Aggrieved by that, a writ petition was filed by the state, your lordships, and the state writ petition was dismissed. Against that, state has preferred an SLP, later a civil appeal was leave was granted, and it was disposed of. Your lords may, I pray your lords may kindly consider the judgment of the Supreme Court. It starts at page number 33. I only take your lordship the relevant portions, sir.
What is the point which you are trying to make? Please tell us.
No,
we know, we have heard you, but this thing.
No, my submission is when the judgment of the apex court has become final and the judgment of the apex court has clearly held that the state and its authorities or anybody should not interfere in the peaceful portion and enjoyment. And these unofficial respondents are trying to assert the property. So, in view of the judgments of the Honorable Supreme Court and as well as representations were made.
So police protection has been given.
It was not given, your lordships. Several representations to the police officers, right from station house officer, ACP, DCP, and DGP, and ultimately no action has been taken, your lordships. So thereby, the writ petitioner, who is a lady and she is unable to protect the property and explaining all these things, she has approached the authorities. Authorities did not extend or otherwise, your lords may kindly, when once the property has reached the finality and the title, interest and possession, including the state and its authorities should not interfere. Can the unofficial respondents would put the law into their hands and again subject the entire issue of asserting the property or encroachment, your lordship? Then the remedy is only to make an application to the police authorities. Police authorities did not give any police protection. Then aggrieved by that order, your lordships, by inaction, this writ petition is filed. And your lords may kindly consider the writ is disposed of, which is at page number 11, your lords.
Page 12, para 7 and 8.
No, your lords may kindly consider. Page 12, para 6, your lord, down. That's not required. I only
No,
require.
you're arguing writ appeal 648.
No,
This
648.
orders were given in 648.
Yes.
648 of 2007, there is no direction from the apex court to provide police protection.
No,
But all has been recorded in the order. Is there any direction to give police protection?
I have only submitted for your lordship's kind consideration. The Honorable Supreme Court has directed that nobody should interfere in the rights, title and possession. To that extent, it is the observation and the finding given by the Supreme Court. And later, your lordship, the people who has sold the property in favor of the petitioner has again started a litigation trying to assert the property, she being the lady. Now, at that point of time, she made an application to all the concerned officers of the state, and they could not give any particular help. So that they are consigned by the inaction, the writ petition was filed. And the writ petition was disposed of, which your lordship may kindly consider. Page 13, your lordship, para 7.
Yes.
There is no dispute in so far as the title of the petitioner is concerned, as the right, title and possession of the petitioner has been upheld by the Supreme Court. Therefore, the right of the petitioner has been crystallized without any doubt whatsoever. Thus, it is the duty of the police to protect the so-and-so of the petitioner from all the concern. Having regard to the factual circumstances of the case, respondents 3 to 6 are directed to provide necessary police protection to the petitioner.
Yes.
Having regard to the factual circumstances of the case, the respondents 3 to 6 are directed to provide necessary police protection to the petitioner to protect her from. However, if there is any dispute with regard to the boundaries, it is open for the respondents to take assistance of the Tahsildar Hyderabad, keeping in view of the order of the special court. My submission for your lordship's kind consent, the remedy of the citizen, having fought for more than 40 years, having the necessary finding and a judgment in its favor. And your lords may kindly, the judgment of this honorable court, following the judgments of the Supreme Court, may pass on your lord, a division bench judgment.
That's it, Mr. Rao. Nothing more. Give that those judgments.
Well,
some doubts had cropped up because we had not noticed the interim order. That's why you have been asked to argue. Nothing else. Now we will pass orders now. Next week.
Your lords, I just pray your lords, the Supreme Court judgment.
There is no this thing. Para 7, the finding is there. We are not deciding the title in rate appeal.
So my submission.
Lawrence Singhal is recorded the finding.
My lord, may I submit, my lord?
1 minute, let him complete.
Para 7, your lordships. In Satyanarayana versus Mallikarjun, AR 1960, the Supreme Court reiterated this principle and went a step further. That for doing justice between the parties, the High Court has absolute discretion and absolute jurisdiction to issue such directions and orders as it may deem fit to do justice between the parties and enforce the law of the land. The only limitations on the wide powers conferred on the High Court and exercisable by it is a matter of issuing writs. The power is to be exercised throughout the territories in relation to which it exercises jurisdiction. That the personal authority to whom the writ is issued is within the territorial territories over which the respective high courts exercise jurisdiction. None of these limitations come in the way of the High Court issuing appropriate direction to further secure the right determined and recognized by the civil court. The power which the civil court has under section 151, the High Court has in much larger measure under 226 of the Constitution. We have therefore no hesitation in concluding that this court has ample jurisdiction to issue a writ or direction to all the authorities, including the police within the state, to enforce the orders of the civil court as affirmed by the High Court in a civil division petition and maintain the rule of law. The police authorities are therefore bound to give all assistance to the appellant, force and see that the orders of this court as confirmed in CRP are implemented, and any inquiry or report of any other authority, revenue so and so, cannot be put an excuse for not rendering the required help to the appellant to maintain his position. This order will subject to so.
Then you have to file CRP, complaint. This is the ratio. Issue is nothing from. Yeah, when victim we are seeing that. Yes, Mr.
I only play your lordships.
All right, got it. Yes.
Much obliged.
Yes.
My lord, contrary to the claim made by the petitioner, my lord, in the civil court earlier, they have entered a compromise. Kindly, my lord, your lordship, may see page 101.
No, the issue is only of providing police assistance, not compromise.
My lord, they have entered a compromise. Contrary to the compromise, now that they are claiming extent more than what they have in the number and which they have already sold. My lord, they have not obtained any injunction against us. They have not, my lord, got any order against us.
And
my
the
lord, in any
Supreme
civil
Court, Mr. Order of the Supreme Court finding recorded in para 7.
No, but that's what, my lord, he had claimed, contrary to the, my lord, earlier what he had stated and claimed in the civil court. My lord, we were not made parties in this, that litigation, we are not made parties. But that, your lordship may kindly see.
No, if you want to take possession of law, take in accordance with law. Don't disturb. You cannot throw out anybody like it, this thing. No person in India can take possession except in accordance with law.
They are doing
that was said 1968, way back in 1968 by Supreme Court, and prior to that by Privy Council also. You cannot, in the garb of that, this thing, the only.
Not doing, let us not, neither we are permitted to do, nor they are permitted to take possession unlawfully. Our respectable submission, my lord, in the guise of taking protection from the police, he wants to throw us out. Right from 2007, this order is suspended. And today we are in 23. Nothing had happened to him. Well, without police protection all these days. And the liner, my lord, the division bench was pleased to direct to maintain status quo. My lord, only with regards to know the police force in this state. May I request the Honorable Court, my lord, to see.
1 minute, 1 minute.
Much.
Yes, we have got it now. 2007 it is state, nothing has happened to you. Fine.
And my lord, neither I may be permitted to unlawfully dispossess him, nor he is permitted.
Yes.
What may say? My lord, police protection, in the guise of that, my lord, they want to kick us out.
Okay, we don't know.
But that's what they are trying, my lord.
File a suit for injunction. File a suit for injunction if anybody wants to kick you out.
My friend's client have compromised with third parties. what is they claimed, but what now they are claiming is different. I just want to read to your lordship, my lord, page
That finding of fact we will not record in a writ appeal against an order that you should have contended in the writ petition.
Well, and we were not given, your admission says that was passed.
Okay.
That was our complaint in the writ appeal.
All right.
We were not permitted nor allowed to.
We have noticed the interim order, mister. Now it is in your favor.
Yes.
Huh?
I pray for allowing the appeals, my lord.
Yes. Okay. Thank you.
Your lordship, interior order, as your lordship knows, it doesn't come in the way of your lordship's disposal.
Of course.
Much obliged.
Yes. No point in done at this point. Yes.
May I please?
No? Which case, my
That matter was the other day had not been. Lord Lordship, I kindly have looked at the proceedings dated 7/6/2023, the last proceeding. They were required to report as to what is the status of the inquiry being conducted by the RDO.
What is the date?
May I state few facts just to.
No, which order? It has to be adjourned, right? So we are asking which order.
But what had happened here is.
What is the order?
But there's no order now passed. They have now been asked to inquire and pass an order. What happened is a case where, under section.
So 10/12/2007 is the order.
Original order is taken.
No, not original order sheet. 10/12. No, you are referring to some order.
Yes.
Yes. What happened?
No, after that, I just clarified. After this, what happened is.
Inquiry may go on. So they have to file an inquiry report.
No, I just clarified. After this, their inquiry was conducted by the joint collector.
29/2/2008.
Lordships are right.
29.
This is the order which they were required to.
Yes. Yes.
What had happened was.
What happened? Did you conclude? No, mister. This order dated 29, you are not having any idea, right? Please see. 29th February 2008 order you don't have. Obviously, he will seek time.
I discussed with him. I also requested him to give an information as to what is happening. But I discussed with him.
But he is not saying that we have to, the result is that we have to show him the order sheet. Your discussion has not yielded any result. Where is the?
I have filed it.
Then it has been done.
No, I'll just give the facts.
No, so you are saying that he should be granted time for what?
No, that's what I'm saying. Just by your lordship, I kindly cancel.
Give us
what happened?
1 minute. We will just.
I'll give.
Please give us 5 minutes. We will get back.
That will not
5
give
minutes.
I prepared a note. There's much more that has gone after that. Because it was.
1 minute.
But that will not. The lorships would kindly consider.
1 minute. Please give us 3 minutes. We will hear you. We need to know what are the facts. This is final hearing. We will have to write an order.
Your lordship has a note. I prepared a note. I've circulated. Lordship may kindly have it. That is what I wanted. Now RDO, what he has done. That is what we wanted.
All right. Then next week, Council for Government Advocate Place for Adjournment list next week. Next. What next week we have said it will come up in weekly list, no? Weekly list it will be included, final hearing. Final hearing, it will come up. Obviously, it will come up at the top because appeal is pending for 18 years.
But
It
I
will-
don't,
Huh?
in fact, I have also asked our clients to go over, to find out whether something has happened or not. We are
Huh?
not aware. So I thought if some more time is, if it is taken up by next Friday, we'll be able to assist the honorable court.
It's a praise for adjournment list after 2 weeks. Yes. Next.
I'm appearing for the respondents in this matter, my lord. In this writ petition, the notification has been challenged, my lord, and the stay has been granted by this honorable court. But thereafter, my lord, in 2006, GO has been issued 62, GOMS number 62, wherein approval has been given by the government for withdrawing the notifications, my lord. Can I pass on that approval notification, my lord, under section 48 of the old act?
No. Notification has been withdrawn.
Yes, my lord. It has been approved, but the 48, it has not been given because there is a stay.
None for the petitioner, so and so for the respondent. In this writ petition, the petitioners have assailed the validity of the notification dated 20th March
Constitutional validity of section 5, 6 and 15 of the present registration of books act. And we consider the requirements making newspapers to submit to registrar and registration of newspapers is an undue infringement of freedom of expression and speech. I will only read 2-3 paras from my affidavit. Unfortunately, the entire first volume was lost somewhere and I have to recreate it. That is the thing. And I could not. But I will, from the affidavit internal pages, I will read the paras 7 of the internal.
AIR manual is there. AIR manual. Or any book with this, not AIR manual, it's 44 volumes. You should ask which volume. You just AIR, it's not one volume. It contains central acts with notes. AIR manual. No, this thing, we want to know this. You get us 5 Press and Registration of Books Act 1867. Press and Registration of Books Act 1867. You are sure the act is still in force? It has not been reviewed.
Under that act,
No,
this
it has not.
registration of newspapers, it is still in force.
not repealed.
No.
Subsequently,
That has been adopted.
200, 300, this thing, old laws were repealed. That's why we are asking.
Adopted later.
When? Get this book, madam, on this book along with commentary.
I'm appealing for the respondent number 1 to 3, Your Worship. Already we filed the counter.
Huh?
I'm appealing for the respondent number 1 to 3.
Huh?
Filed counter.
Huh?
I'm appealing for the respondent number 1.
That's a fine. Third time you are telling. After that, what is important? Their sentence is important. Or you want to file counter?
Already
No.
filed.
We will not permit you to file counter after 18 years.
No, already we filed the counter in this matter, Your Worship.
That's all right. Then argue when your turn comes. Sit down. He listen to him what he argued. Get the book, madam. Registration.
May I read para 7 of the affidavit?
1 minute, Mr.
Internal para. May I read the para?
1 minute. We are also doing the same thing. We will hear you out. Yeah. One more copy for his love. Your grounds is silent that we are going to see. See, it's very easy to challenge the provision. Rahul is ready. Rahul, This act is still in force, find out. Write down this act. Still valid, nor repealed or modified something. Immediately come back. 1867. Repeal or still in existence, any amendment made, whatever. Particularly to section describing the procedure, that's all. Constitution. Constitution of India.
I would point out to one glaring anomaly, request honorable court's permission. One is that for books, there is no need for any registration. For books, publishing books. I can publish 100 books today itself without any registration. For newspapers only, that restriction is in place. And in entire objection readers,
No, what restriction?
that it has to be registered. So I may write a very seditious book, or 2 or 3 books I can publish today. No pre-censorship or no sort of any restriction. But if I want to publish any newspaper,
Distinction is obvious, right, between a newspaper and a book.
no, that has
distinction is obvious.
adverted to in any objects and reasons also.
Yeah.
That's what I mean.
Oh,
I said
This act is amended in 23.
22. And then periodical, printed periodical, they have introduced the name newspaper.
This amendment in 23.
Special Law Repeal and Amendment Act 1920.
It has been amended, right? But this is the old, same copy you are giving. Act, no, has come into force. These provisions have been amended. Have you examined in 2023? That's what we were wondering, that 1867 law.
67 law. And then
No, it has been amended in 2023.
1922 also, only 1922 they introduced the word newspaper. And I may be given, because I lost that first
No,
one.
Mr. Simple question is, you are challenging the validity of 1867 law. We are, this thing, the provisions of that act have been amended in the year 2023. Are you aware?
No, prior to that.
Huh?
So I'll take some time.
So should you not examine this?
I'll take some. And the first volume also lost. I have to recreate that first volume.
That we don't know. Nobody must be interested now. Yes. But what is it? I mean, it provides for this thing. If you don't comply with the provisions of the act, there is a penalty. What is wrong with it? There should be no, according to you, no control.
Newspapers.
Anybody can publish.
It should be on par with books, printed books.
Okay. What else? We have understood, right? So you are saying that books and newspaper are can be, or reading material can be same.
Otherwise, it is amount of pre-censored. Because particularly this one, we have given the first application on
More wider reach. You can read it. Book is
16/8/2004.
That's why.
And only on the interim order of this court.
It's about hypotension and two-page newspaper and even not registration, no consequences.
On 16/8/2004, we have given the first application for title verification. It was not done. And only after we approached this court by WP 2000-2258/2004, there was an interim order. On
Which newspaper do you publish? Which newspaper?
Law Animated World. Law Animated World.
No, it's a newspaper.
Sorry,
It's a newspaper.
It's a fortnightly. World Law Fortnightly. Fortnightly.
Newspaper.
Fortnightly.
Fortnightly newspaper.
And the printed version is stopped with the last year. We have closed that.
Huh?
Printed version we have closed with the last year. After heavy losses. 18 years we have done.
That.
So practical implications, and this is the constitutional implications of this.
So what is, let us see. Restriction, what restriction? What is section 5 say? That printer and publisher has to appear before district magistrate and has to make a declaration. So what is unconstitutional about it? Any activity has to be, any activity, whatever activity can be, has to be regulated. You cannot say that if somebody, no, please, we are trying to understand, listen to us. What we are, like, you are publishing a newspaper. Somebody is asking you that you get yourself registered and appear before district magistrate, give the declaration. How is it unconstitutional? You should not be held accountable for anything. You can get away by publishing anything and it should not be an offense also.
If anything is seditious or if anything is illegal, they will take action afterwards. Otherwise, it will amount to pre-censorship.
Where is the, yes.
And they never said it is for sovereignty of integrity of India or security of state, all those restrictions, reasonable restrictions in Article 19. They have not been adverted to for this.
So we want to understand what is your challenge to this section 5. First read what is section 5. What is section 5? You are arguing a final hearing matter, right?
That's what I said. I will request time because I lost the first prize.
No, nothing. Forget about time.
I will read para 7 of my affidavit.
That we can also read. You argue. First tell us these are the provisions which you want to challenge. Why, what these provisions require you to do. What is the challenge? That's very like Article 14, 19. That's all always a general challenge. You have to lay down the factual this thing. There is a requirement of pleading also in the written.
Need to give a declaration. The act is
So, Mr. We are surprised that in a writ petition challenging a statutory provision, you will not even read that provision. Yes. What is it?
I will request some time.
No time. This is since 2005.
That's all. I have lost that first volume.
That's why you have lost. Because client must have forgotten that he has filed a petition.
Last time I have kept these volumes and first volume I have lost. I have given entire thing in the running index also we have cited this. After 2 weeks.
This is what, nothing 2 weeks. This is what it is, right? You will challenge a provision, court will supply you a copy of the act. This is Mr. Administration of Justice by equal partner in the administration of justice. This is it. That the court is required to supply you the act.
Thanks, sir. No newspaper, section 5 says, rules as to publication of newspapers.
Nothing, privilege, counter this, and counter.
Present registration of books act. Yes, straight away I may say that there is no registration of books.
You read. All right, it's your petition, argue whatever way you
Section
want.
5 rules
We
as to
cannot.
publication of newspapers. No newspaper shall be published in India except in conformity to the rules hereinafter laid down. And to the printer and publisher of any such newspaper shall appear in person on behalf of according to the rules made on section 30 for district president and supplement within local division subdivision shall be presented. And do a declaration. Every declaration shall specify the title of the newspaper. And yes, and declaration shall leave India for that is it. Keepers of fourth and keepers of printing press to make declaration. But books, there is no provision for registration or declaration for books. This is the Press and Registration of Books Act, 1860.
We have given you copy of
I acknowledge.
No, don't tell us that
Gratitude.
that we don't know what is the act. We have given you, we have read it and very distinguished. What is this?
So what I am saying is, I will read the para 7 and the 8, 9, they continue the entire talk. I may attempt here to present a brief overview of the 1867 Act and subsequent legislation affecting it, which I submit to go to substantiate our contentions that the 1867 Act and subsequent legislation and executive measures result in gross infringement of our fundamental rights of freedom of speech and expression guaranteed by Article 19 of equality before law by Article 15 and of right to life by Article 12. The 1867 Act was made by the British colonial rulers mainly in order to secure the information as to and collective publications made in the country from time to time and mainly concentrate on books. The word newspaper is not even used in the original Act or in the statement of object and reasons leading to that enact. However, it is therein that a prior declaration of the first time sought for printed periodical work containing public news or comments on public news. And Section 5 of the Act, which is couched in negative language, and also penalties of fine and imprisonment of 6 months are also imposed for contravention of section in Section 15 of the Act. Obviously, the petition bill is introduced the section to curb the growing national awakening and movement in the country, for which the newspapers will serve as a chief entity. This is a pre-constitutional law, and there was no constitution in those times, but autocratic rule by imperialists closely in various legislative and executive jobs. Unfortunately, the very same autocratic provisions are being continued in India by the present rulers too. However, it is obvious that this patent restriction not even effective to have been made for the sovereignty and integrity of India, the security of the state, etc. This 1867 Act was chiefly amended before independence by the Press Law Repeal and Amendment Act 1922, 14 of 1922, by which for the first time the word newspaper was substituted for printed periodical work containing public news or comment on public news in Section 5 thereof. 8. After independence, this repressive law, a part of the laws incidentally castigated by our national leaders who fought for our independence, has been shamelessly adopted by 2 adaptation orders, ACAO 1948 and ALO 1950, by the central government, President of India. However, it is submitted here itself that such adaptation under Article 372 cannot in any way save a law as existing law if it is contravening the requirements of Article 13 due to any patent infringements of fundamental rights embodied in the Constitution. In 1947, a press law inquiry committee was instituted by the central government, which was required to go deeply and comprehensively into the entire history and development of the press law in India and submit suitable suggestions for improvement. It submitted its report in 1948, on the rights for which press and registration of books amendment bill 1952 was introduced in the parliament. However, the same was withdrawn in August 55, since by that time a press commission had been constituted by the union government and it has submitted its first century comprehensive report. On the lines of the first press commission report, the press and registration of books amendment bill 1955 was introduced in parliament in August 55 and was adopted after lengthy but insufficient and uninformed discussion and debate that took place for a few hours on 21 November 55 and for a few minutes the next day. I submit here that it is pertinent to note that the then Minister of Information and Broadcasting, Dr. Keskar, while moving the above said press and registration of books bill 1958 has clearly stated, I would like to make at the very outset one thing clear, because that will brought to my notice by the of the proprietors and then also by the comments published in certain papers, more especially outside the country, that this is an indirect way of controlling the press. It is clear that the present is a purely kind of statistical measure. But what I want to make clear is that the object of the bill and appointment of central listing authority are concerned purely with the statistical and business side of newspapers. However, the Honorable Minister as well as the members of Parliament missed the principal point of prior declaration being required for newspapers only, in contrast to books for which no such restriction was placed. Further, there was no formal discussion of the bill and it was almost unthinkingly and aggregately adopted. I submit that we petitioners are not against any central registering authority, but only against prior registrants. Here I submit that the Honorable petitioners 1 and 3 are no more, and only 2 and 4. 2 is very old now, about 90 years. Okay, then 2 is about 90 years. We are not against any central registering authority, but only against the prior restraint, pre-publication restraint being imposed on newspapers by sections 5 and 6 and consequent penal provisions of section 15 of the Act. Thereafter, Act 26 of 1960 also brought in some further amendments in the above sections, and still later amendment acts are not much relevant for the purpose of the petition. That the original state of objects and reasons of the 1867 Act contains not a mention of the word newspaper or even periodical printed form, and is exclusively devoted to collecting and securing books published in India, and is that too by purchasing it from the publishers. Shows that section 5, 6 and 15 of this Act sets from the right of over-include books, in addition to being affected by undue disclosures. By no publication restraints are imposed on books, which also could be published almost daily without any prior declarations being given. Unjustly and arbitrarily prior declarations were sought for newspapers, which thus equal protection of law is denied, no reasonable classification in apparent in enactment. In fact, no such classification is made, and hence the sections 5, 6 and 15 are infringing Article 14 and liable to be struck down on that one too. I already submitted that sections 5, 6, 15, etc. of the 1867 Act are a serious infringement on the right guaranteed by Article 19(1), since the restrictions to the requirement of prior declaration are not made in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency, or morality, or in relation to contempt of court, defamation, or incitement to ill effects, which consideration don't render any reasonableness to restrictions.
See, you're challenging 5, 6, and 15, right? You only confine your submissions to the extent how those are infringing your rights. If you see 5, 6, and 15, it contemplates the procedures.
That procedure itself is unmoral.
How?
When the procedure was not placed for books, which contain the same material, which can contain the same material, pernicious material, or illegal material.
No, books,
That is only books and
books and newspapers are essentially different. Like
that
you cannot.
has not been explained in the objects and reasons. It has not been stated. No,
No. So your submission is that since the provision does not prescribe for registration for publishing books, and it only prescribed, therefore it should be 1 minute. So therefore it should be struck down.
That is one of the reasons. One of the reasons. And
So you are-
they don't come under all these restrictions, don't come under any of these things.
So there should be no registration of a person, no, his antecedent should not be checked. Anybody can, anywhere can publish the newspaper, right? Without owning any response.
For statistical purposes, there is a Statistics Act, there is statistical authority. They can collect the information and these things. They can require the newspaper to submit that information. Because we are explained it is only for statistical purposes we are collecting. Concern Minister in 1955. That also we have given in the minister's statement. I will read it out. And
Arey, Mr. We are trying to understand how the provision of law can be challenged on two grounds, right? Either the legislative body has no power to enact the law, or secondly, it is in contravention of the fundamental rights. So what is wrong about Section 5 asking you to register?
it is a contravention of fundamental right because it is imposing a pre-publication restraint. Unless he gives me a title and I register under the title and he gives me permission to register, I have to put the newspaper.
Registration under Aadhaar Act, even if there is a law, even that you register under the activity.
Look at it. The first application by me was made.
No, this is not a question on facts, right? This is you are challenging validity of law.
How it happened? On 16 August 2004, first application was made. 16 August 2004. We followed the provisions. But they have not decided that they not help me any time. And then they had to file a petition 2004. An interim order was granted to process it.
1 minute, 1 minute. Yes, Mr. Counsel. You are 1 minute.
Morning, Lordship gave me liberty to make a mention of the CRT.
Why are you not mentioning? That means you have filed down now, right?
We have already numbered my lords.
So we have passed an order in item 1.
My lords. I am informed that the court officer is attaching the property, my lord. This is relating to attachment in EP 13, my lord. Similar order was lodged in EP 13, my lord. That order is relating to EP 12, my lord. Two orders.
Get it. Lunch motion, Mr. Yes. Same order we will, there is no need to pass any order in fact. We have already passed an order, right? Same order you are challenging.
Different order, my lord.
What is EP? Another this thing. So you will get some more money. Lighter vein. We will hear you. We will hear. We will hear you. Yes. Lunch motion. Send, madam. Yes.
And finally, the title verification was sent to me on 25/1/2005. So even for title verification, they have taken about 6 months. After title verification, they did not take my declaration up. Again, I had to approach the court and got an interim order, and then they have taken the declaration. So the Honorable Court may see, following the procedure of law, how we were subjected to this suffering and losses and loss of reputation, which we have released on 2004 also in anticipation. The Honorable Court may say 3 judges of this court had attended that function also. Release of this book.
No, that has nothing to do with validity. That has nothing to do with validity of a provision. Whether everybody attends or nobody attends doesn't. We will examine constitutional validity of 5, 6 and 15, not on the basis 3 attended, 5 attended, nobody attended, nothing happens.
It is true that it affects Article 90.
Circulation has been stopped. Circulation has been stopped, no? That you are not.
We have stopped.
Acha, digital mode.
Practical implications now, we are dealing with the basic constitutionality of these sections.
Without even bringing an act dealing with the basic constitutionality. Joke, Mr. Joke. Yes, nice joke. Yes, go ahead. You are reading para 6 and 7. Read. This is the argument really. The whole burden is on the court because it has taken oath to do justice, right?
That the original state for objection contains not mention of the word newspapers that while no publication restraints are imposed on books, which also could be published almost daily without any prior declaration being given, unnecessary and arbitrary prior declarations are sought for newspapers. Is that the equal protection of law is denied. No reasonable classification is apparent in enactment. In fact, no such clarification is made, and hence the sections 5, 6, and 15 are infringing Article 14. I have already submitted that sections 5, 6, 15, etc. is against citizen are a serious infringement of the rights guided by Article 19.1. Since the restrictions due to the requirement of prior declaration are not made in the interest of sovereignty and integrity of India, security of state, friendly relations with foreign states, public order, decency or morality, or in relation to conduct of court, defamation or incitement to affairs. These are the only reasons on which any restrictions can be made, or any law restricting can be adopted or can be approved.
So, Mr. What are your submissions? Tell us. This anybody can read, right? Anybody in the court can read this. What are your challenge to the ground? 5, 6, and 15. What are your submissions?
They are violated Article 19.1. Article 91 deals with freedom of speech and expression. Which in
Thank you. We did not know that it deals with freedom of expression. We did not know that. Sorry. Thank you. Thank you. Thank you for telling. What else? Violative of Article 19.1. Violative of Article 14.
14. Because,
because
it has not
no books.
Books and newspapers.
Because such regulation is not on books. What else?
And Article 21 of the Constitution is also related because the procedure is cannot be considered reasonable, fair, and just.
Okay. All right.
I have brought the factual side also. But even giving the title verification, an interim order of this court was necessary, and then it took 6 months. And after title verification for declaration, again it took 3 or 4 months. Again on the basis of a court order. If some time, more time is granted, I will recreate the first volume. And
No, nothing, no create. This is the last day of your case in the High Court. Don't recreate. Once you have created, good enough. Don't recreate. This is the last day of your petition in the High Court after 18 years. No, don't forget about it. Target. Fine. Anything else?
These are the 3 grounds. Seriously infringing Articles 14, 19.
Seriously.
Understanding the basic difference. The Honorable Court can understand even if title verification is done only due to the court order, and that too after about 6 months.
No. We are dealing the validity of statutory provision, Mr.
Statutory provision in its application can also be considered. What I am saying is a statutory provision which denies the freedom of speech and expression in its application.
So according to you, no activity can be regulated. You should be let free and do whatever you feel like. This is what it is. Fine.
We are not against it. That we have made it clear.
No question of for and against. We will. We don't need your certificate. Whether you are against.
Statistics Act is there. Statistical Authority of India is there. If it is only for statistical purposes, there is what in Lok Sabha debate, the Minister of Information and Broadcasting, that also I have reproduced it in that first point.
All right. Anything else? That's it.
That's it. On these 3 grounds, it has to be struck down.
This is your submission. Whether it will be struck down or not, we decide. Correct?
Certainly.
Yes. Yes. Give us the bare act, our act, copy. In this writ petition, the petitioners. Petitioners have assailed the validity of
Only online issues are being.
admittedly the aforesaid um,
Number one is no more.
please sit down. You have not told us the facts. Now we are doing it. You have not told us the facts, nothing. Fine, sit down. Please sit down. Don't interrupt. This is a ground for SLP. Don't correct us. You should say that High Court has wrongly said this and all that, right? See, this affidavit is Bala money. Next.
Your lordships. This matter is infructuous, your lordships.
Huh?
This matter is infructuous, your lordships.
But why should you wait till it is called? Supposing it would not have been called, you would have never said. Huh? Why do you wait till it is called? Huh? Learned counsel for the petitioner submits that the writ petition has been rendered infructuous on account of efflux of time in view of opposite submission. Same is dismissed as infructuous.
Willard, I beg to appear in this matter.
Huh?
Willard, this is a writ petition directed against an order of resumption passed by the revenue officer.
It will take some time, right?
No, Willard, it is a very short matter, just 1 minute.
Oh.
Impugned resumption order has been passed without giving notice to the petitioners who are the purchasers of the subject land under registered sale deeds. Second respondent in the writ petition is the original assignee.
Yes, madam, is it so?
No, my lord. I filed a counter affidavit.
No. The order has been passed after hearing the petitioners. Huh?
Yes, your lordship.
So she says it is so.
The counter affidavit filed clearly says that form 1 notice has been given before resumption.
Yes. Yes, Mr.
Malad, did you kindly see the order itself, Malad? The order at page 11.
Page 11.
Yes. The notice is at page 13.
13.
Yes. So from this notice, Malad, the order has been passed. At page 13, Malads will see the 24th February 2005.
Now what?
Well, at page 13 is a form 1 notice. And that is given to the second respondent assignee M.A. Khadar. Khadar, who is the vendor of the petitioners. Khadar, whereas you have, it is found that you are assigned.
When have you purchased?
I have purchased on 13th of October 2004. My sale deeds are enclosed valid at page number 14. I have purchased on 13th of October 2004.
Then where is the order?
And the order, first is notice is at page 13, order is at page 11. Order, impugned order in the writ petition is page 11.
11.
14th March 2005, minute. Passed by the Mandal Revenue Officer. And I may read the order, Mallet. In the reference first cited, additional Mandal Revenue Inspector of this office has reported Muhammad.
We have read it. Yes, assignment patta has been cancelled.
Assignment patta is cancelled. Resumption proceeding, Malad. Now names of the petitioners are mentioned in the impugned order in the table, Malad, in the middle of the page. But the petitioners were not given any notice at the end of the order.
Where your names are mentioned?
My names are mentioned in the impugned order at page number 11 in the table, Malad, which is document date and name of the vendee. I am the vendee. And name of the vendor. So my names, I am, the petitioners are 5 in number, Malad.
Yes, all right. Correct. So it has to go back.
Yes, the only prayer, Malad.
All right, on it.
My prayer
Yes,
is
madam.
only that an opportunity has to.
It has to go back, right?
My lord, the last line of the tabular column.
No, where is the notice sent to the petitioners?
My lord, the last 2 lines of the page 11, my lord, if your lordship peruses.
11?
Form 1,
No, first come to notice at page 13. Where is the notice issued to the petitioners?
Will not.
Huh?
True.
Then
The last
why
two
don't
lines.
there is
Will
no
not.
dispute on facts.
Will not. The last two lines at page 11, if you're
No,
not.
we are asking plain and simple question.
Yes, my lord.
When
As they were
the
not-
notice has been issued to the petitioners.
As they were not
Where is the-
residing, as they were not residing in the village.
They have acquired the right by virtue of a registered sale deed, madam. How can they not be heard?
My lord, the last two lines of page 11, it says, the notices were displaced at the Gram Panchayat notice board due to the assignee not residing in the village and.
No, we will say that you have vehemently opposed, argued for 3 hours. We will say that in the order if that satisfies. At least be fair, madam. And you as an officer of the court, you are standing here to assist. Not necessary that every case, whatever is said has to be opposed. Nothing. If the order has not been passed, you can say that please do not record my concession, understandable. But this fact that he has not been heard, you cannot dispute. Right? In this petition under Article 226 of the Constitution of India, the petitioner has assailed the validity of the order. Validity At 29, you are not having any idea, right? Please see. 29th February 2008 order you don't have. Obviously, he will seek time.
I discussed with him, I informed, I also requested him to give an information as to what is happening, but I discussed with him.
But he's not saying that we have to, the result is that we have to show him the order sheet. Your discussion has not yielded any result. Where is the?
I have filed it, Milord.
Then it has been done.
No, I'll just give the facts.
No, so you are saying that he should be granted time for what?
No, that's what I'm saying. Just by your lordship, I kindly consent.
Give us
What happened?
1 minute. We will just.
I'll give what.
Please give us 5 minutes. We will get back.
That will not
5
give
minutes.
I have given a note. But there's much more that has gone after that. Because it was.
1 minute.
But that will not, your lordships would kindly consider.
1 minute. Please give us 3 minutes. We will hear you. We need to know what are the facts. This is final hearing. We will have to write an order.
Your lordship has a note. I prepared a note. I've circulated. Lordship, I kindly have. That is what I wanted. Now RDO, what he has done. That is what we wanted.
All right. Then next week, Council for Government Advocate Place for Adjournment list next week. Next. What next week we have said it will come up in weekly list, no? Weekly list it will be included, final hearing. Final hearing it will come up, obviously it will come up at the top because appeal is pending for 18 years.
But in fact, I have also asked our clients to go over to find out whether something has happened or not. We are not aware. So I thought if some more time is, if it is taken up by next Friday, I will be able to assist the honorable court.
It's a praise for adjournment list after 2 weeks. Yes. Next.
I'm appearing for the respondents in this matter, my lord. In this writ petition, the notification has been challenged, my lord, and the stay has been granted by this honorable court. But thereafter, my lord, in 2006, GO has been issued 62, GOMS number 62, wherein approval has been given by the government for withdrawing the notifications, my lord. Can I pass on that approval notification, my lord, under section 48 of the old act?
No. Notification has been withdrawn.
Yes, my lord. It has been approved, but the 48 it has not been given because there is a stay.
None for the petitioner, so and so for the respondent. In this writ petition, the petitioners have assailed the validity of the notification dated 20th March
Constitutional validity of section 5, 6 and 15 of the present Registration of Books Act. And we consider the requirements making newspapers to submit to registrar and registration of newspapers is an undue infringement of freedom of expression and speech. I will only read 2-3 paras from my affidavit. Unfortunately, the entire first volume was lost somewhere and I have to recreate it. That is the thing. And I could not. But I will, from the affidavit internal pages, I will read the paras 7 of the internal.
AIR manual is there? AIR manual. Or any book with this, not AIR manual, it's 44 volumes. You should ask which volume. You just AIR, it's not one volume. It contains central acts with notes. No, AIR manual. No, this thing, we want to know this. You get us 5 Press and Registration of Books Act 1867. Press and Registration of Books Act 1867. You are sure the act is still in force? It has not been repealed.
Under that act,
No,
this
it has
registration of newspapers, it is still in force.
not repealed.
No.
Subsequently,
It has been adopted.
300, this thing, old laws were repealed. That's why we are asking.
Adopted later.
When? Get this book, madam, on this book along with commentary.
I'm appealing for the respondent number 1 to 3. Your Worship, already we filed the counter.
Huh?
I'm appealing for the respondent number 1 to 3.
Huh?
Filed the counter.
Huh?
I'm appealing for the respondent number 1.
That's fine. Third time you are telling. After that, what is important? Their sentence is important. Or you want to file counter?
Already
No. We will not permit you to file counter after 18 years.
No, already we filed the counter in this matter, Your Worship.
That's all right. Then argue when your turn comes. Sit down. He listen to him what he argued. Get the book, madam. Registration.
May I read para 7 of the affidavit?
1 minute, Mr.
Internal para. May I read the para?
1 minute. We are also doing the same thing. We will hear you out. This thing. Actions. Yeah. One more copy for his love. Your ground says silent that we are going to see. See, it's very easy to challenge the provision. The Rahul is right. Rahul.
I appear, Mr. Lord.
Yes.
One WP number 7859 of 2023.
163.
Yes, my lord. Yes, yes. That's the matter, my lord. I appear. There is one writ petition and 3 contempt petitions now before your lordships.
Yes. Oh.
2 contempt petitions filed by the petitioner. 1, my lord, filed by the by Huda. That's the subject matter, my lord. If I may show to your lordships, my lord, it lies in a very short compass. The writ petition lies in a very short compass. My lord, we have prepared a list of dates. If your lordships will permit me to kindly give it to your lordships. The subject matter of the writ petition, my lord, is survey number 725 bar 21, survey number 725 bar 23, survey number 725 bar 24. Now, my lord, the claim in the writ petition is for a mandamus to injunct the respondents from interfering with our possession of the property, excepting in accordance with law. Now, my lord, your lordship may straight away come to the second date, my lord, the list of dates, 1953. My lord, a civil suit came to be filed before the City Civil Court, Hyderabad, by one Srimati Sultana Jahan Begum, the daughter of Nawab Mohiddin Dawla, seeking partition of the properties of Nawab known as Asman Jahi Paiga. Scheduled property was part of the Paiga. Now, my lord, that suit is the one which is now before your lordships on a transfer order. It is numbered as 7 of 1958. In that suit, my lord, a preliminary decree has been passed and the properties were apportioned among the legal heirs of the plaintiff. Now, my lord, kindly turn to the next date, 27/4/1968, which is very important so far as the petition is concerned. My lord, a sale certificate was issued in favor of Mohammed Farooq Qureshi,
Mohammed Farooq Qureshi, my lord, is the father of the petitioner. Declaring him as absolute owner of the scheduled property by this honorable court was put in his full possession and enjoyment of the scheduled property. Now, my lord, may I trouble your lordship to kindly look at the document at page 15. If your lordship are kind enough, my lord, to turn to page 14 of the writ order.
14.
Yes, my lord. It is marked as Exhibit P1. Issued by this honorable court. This is to certify that Mohammed Sheikh Qadar Ali was a purchaser of auction property number so and so, so and so. But kindly come down, my lord, to about 10 lines from the top. I am not going to trouble your lordship. The said purchaser, namely Mohammed Sheikh Qadar Ali, approached this court and has filed an application dated so and so in CS number 7 with a request to issue said certificate of said property in the name of son, namely Mohammed Farooq Qureshi. Accordingly, he deposited the said property in the name of son so and so. Accordingly, he deposited said balance amount of 4,250 along with a delay fine of 1,200, total amounting to 6,650 as per the orders of this court dated so and so. It has been confirmed that he has now become the rightful owner of the said property, measuring acres 51.13, situated in survey number so and so of Shamsadabad Paiga village, and this sale certificate is issued. This is the source of our title. My lord, I'm going to skip the rest of it. I'm not going to trouble your lordships. Then, my lord, please come to the next page. 9/7/2007. Mohammed Farooq Qureshi passes away, leaving behind his wife and 2 children, including the petitioner herein as legal heirs. In from 2007 to 2021, nothing happens. In 2021, there is some problem, and therefore we file a writ petition bearing WP number 5418 of 2021, seeking to declare that the action of the respondents in interfering with the lawful and peaceful possession of the scheduled property is illegal. In that writ petition, there is a significant order which has been passed, which your lordship may kindly turn to 4th of March 2021. Your lordship may kindly turn to page 21 of the writ papers. The order, my lord, dated 4th March 2021. I'm going to skip the first portion. Please be kind enough to turn to page 23. My lord, that the lordship may kindly turn to paragraph number 4 at the bottom of page 23. Shri Y. Ramarao, Learned Standing Counsel for the 4th respondent, HMDA, submits that they are conducting survey in respect of survey number 725/2022 only. It is not our property, my lord. But they are not interfering with any of the other properties other than the survey number, and the survey is being conducted only to identify the property of HMDA to fix its meets and bounds. No difficulty, my lord. With respect to 725/2022, I have no right. My writ petition was confined to 725/21, 725/23, and 725/24. Your lordship gets it in the first paragraph at page 23. And now your lordship may kindly turn to paragraph number 5. By recording the said submission, the 4th respondent, writ is disposed of. In the event the 4th respondent HMDA finds any violation on the part of the petitioner with regard to the subject lands, the respondents are at liberty to initiate action against the petitioner by following due course of law. Therefore, the stand was quite clear. We are not interfering with the property which belongs to the petitioner. We are conducting survey in respect of some other property. If in respect of that property, I interfere, take action. No difficulty. Now, this order, this undertaking given to this court was violated, which resulted, my lord, in our filing a content petition, namely CC number 816 of 2023. I'm sorry, Lord. It is content petition number 334 of 2023. I'm sorry. That is one content petition that is pending before your lordships.
Yes.
Our grievance is that notwithstanding this submission that was made to this court and recorded by this honorable court, there is an interference with our position. That, my lord, is content number 334, 2023.
So your grievance is about violation of the order passed on 4th of March
My lord,
2021
that's right. Yes, my lord. Yes.
in WP 5418.
Yes, my lord. That is the order that was passed by this honorable court on the 4th of March 2021. Your lordship's right. That is the subject matter of contempt petition number 334 2023. Now, my lord, there is another thing that happens. Again, there is an interference. Notwithstanding this contempt petition is fine, and therefore another writ petition was filed. The lordship gets it on the 20th of March 2023, which is a very important order. Petitioner, this is the present writ petition. It is 7859 of 2023.
20th March.
Yes, brother. There is an order in this petition dated 20th of March 2023.
20th March. Ah, yes.
Yes, brother. But your lordship may kindly look at that order.
This is referring because this court is dealing with these matters.
Yes, yes, yes.
7B, 7 and 13.
Yes, my lord, because by virtue of a transfer order, all these matters which are pending before the civil court has been transferred to this honorable court. That's how, my lord, CS number 7 comes before your lordships.
Yes.
Now, my lord, please look at this order dated 20th of March 2023. May I place that for your lordship's consideration? This writ petition has been filed alleging interference of the respondent authorities in the peaceful possession of the petitioner of the subject land to an extent of so and so said properties. Admittedly, petitioner claims to be purchaser of a preliminary decree holder in CS number 7 of 1958, pending before a division bench of this court. Since title claimed by the petitioner or the subject property forms part of CS number 7, 13 and 14 of 1958, registry is directed to list this case for the concerned bench after obtaining necessary orders from the Honorable Chief Justice. That's how, my lord, the matter comes before the division bench of this Honorable Court. The learned single judge said, even though it has been transferred, since the main case, CS number 7, is pending before division bench. Now, let's see the last sentence. It's important. Meanwhile, status quo shall be maintained by both the parties in all respects. Now, my lord, according to us, this order has been flagrantly violated by the authorities, which has resulted in our filing another contempt, which is contempt number 816 of 2023, which is now pending before your lordships. That is the second contempt. While on this point, I must also point out to your lordships that HMDA now says we have violated and therefore they have filed a contempt. That is CC number 925 of 2023, which is also now for your lordships. The allegation, my lord, is that we are putting up construction in violation of the order dated 20th of March 2023. Our allegation is that in violation of the order dated 20th of March 2023, they have demolished construction which existed on the property. This is the matter, my lord, before your lordships in the contempt jurisdiction.
Yes, so counters have been filed.
Yes, I will show your lordships the counters.
Counters have been filed, no?
Counters have been filed, my lord. Sir.
So what is to be done today,
My
Mr.
lord, sir,
Bhagwan?
there has been a fraud on this court, my lord, your lordship.
Yeah. We will hear you.
Yes.
We
I will come to that. All right, come to that.
yes. Let me finish.
Let me come.
Yes.
Now, my lord, today, my only request, your lordship, is this order dated 20th of March 2023, granting the status quo please clarify it. You say that they should not interfere with our possession. And now, Mr. Montanier watches, there is another interim order that has been passed in another petition that we have filed. It is not before this court. Now, today, let me look at this order. Look, we should put an end to this. This addendum-ize must stop, my lord. And all this on the basis of a court order. It has really become a lot of addendum-ize story. Who is changing whom? Now, my lord, please be kind enough to see the order which has been passed recently on the 23rd of July, on the 5th of July, 2023. It is the contention of the learned counsel for the petitioner that when the revenue authorities and station house officer are interfering with the petitioner's possession of the subject property, petitioner was constrained to approach this court by filing WP number so and so, and this court was granted interim orders in the said writ petition on 12th of March. It should be not 12th, it should be 20th. I think it's a typographical error. Directing both the parties therein to maintain status quo in all respects. It is a further contention of the learned counsel for the petitioner is that even after granting status quo orders by this court, respondents have erected a police picket in front of the petitioner's land and totally blocking the ingress and egress to the petitioner's land. Further, it is a contention of the learned counsel for the petitioner that the police are interfering with the civil disputes between the petitioner and the respondents in WP number 7859 of 2023 and not allowing the petitioner to enjoy his own land. In these circumstances, there shall be interim direction directing the respondent police not to interfere with the civil rights of the petitioner in any manner excepting in accordance with law. This, my lord, is our grievance against the police. The other writ petition was our grievance against the HMDA, where that status quo was passed. Now, my lord, that I have a sale certificate in my favor, which has been granted by this honorable court, is not in dispute. My title to the property is governed by the document, is not in dispute. The lordship may kindly look at the certified copy. I have shown the lordships. I have a certified copy of the sale certificate. Even today, we have obtained a certified copy, but I have it with that. I show it to the lordships. Now, if that is the position, now look at the prevarication of the state, the HMDA, in the counter that has been filed. Now, let me point out, your lordships, the counter filed in the writ petition. But I must point out, your lordship, there are two counters.
So is it this petition based on a subsequent cause of action? Because it appears
yes
previously also your relief was same, not to interfere.
Yes, this one is against the police.
This is police and
yes.
The previous one was HMDA.
Yeah, respectfully.
And now against
now what is before your lordship now is against the HMDA.
Acha, HMD.
Yes. The writ petition against the police is not before your lordships today. Now, I want your lordships to kindly see the counter affidavit that has been filed. Now, not in the writ petition, your lordship will kindly see the reference to this sale certificate is found in paragraph 3 of the writ petition.
What is to be done? This is today. It is for admission.
Yes, bro. It is for admission.
Yes. We will hear at this thing. Mr. Advocate General will hear the petition.
My lord.
Everybody else is waiting, or at least at the end of the list.
My lord, I want to point out one other thing before my lord and lord say. Can I make one submission?
No.
I want to invite your lordship's consideration to an earlier order that your lordships were kind enough to pass in this writ petition. Where is the order? Yeah. In this writ petition, your lordship were kind enough to pass an earlier order. Well, that's the order which your lordships have passed on the 20th of March No, it's not.
15th September.
I'm sorry.
15th September.
Very good. My lord, it is the order passed by your lordships on the 15th of September 2023.
No, that's all right. But
Yes, my lord.
But
My lord, what is being stated before your lordships, as I understand by the learned application.
35966 is non-existent.
Yes. Now kindly see the report that has been given before your lordships.
Yes.
We have not seen it, but we would request your lordships to see it and tell us what it says.
And there is also a reply file, my lords, that they are also very necessary to be perused at this moment. I'll just take.
No, we just wanted to, everybody else is waiting. We just wanted to understand what like the scope of this proceeding. What?
Yes.
No, that's called
admission it requires.
Now I'll give you a lordship the background.
Yes. So Mr. Report says that such a writ petition is not existent.
But I must tell you,
like no record.
I understand. But as an officer of the court, I want to take a stand.
Yes.
But if really a writ petition WP number 35966 of 1997, as stated by the petitioner, does not exist, and that has been referred to in this writ petition now before your lordships, it's a serious issue.
That's what.
I agree, my lord. Nobody should play with the court records, and person who plays with fire cannot complain of burnt fingers. But no doubt about it. I mean, independent of the brief, but I think it's a serious issue. Let it be fully investigated. Please have it fully investigated. And if really parties have played a fraud on this court, whoever has done it must be punished. Otherwise, my lord, the system will crash. Please do it, my lord. I have no objection. Therefore, my lord, let us keep that proceeding separately because it's a serious issue.
Serious, and the report is says that there are no this thing such writ petitions 35966, 35970 have not been registered.
Well, that is relied on in the writ petition. That is relied on in the writ petition.
Yes.
Well,
We have seen that you have relied on this.
It should be investigated. Let it be investigated.
Now investigated what, like report of the registrar judicial is there? You now we will ask the registry to supply you a copy.
Yes.
You respond to this.
Yes.
My lord, sir,
Where have you got this copy and all that?
And in fact, my lord, it becomes a serious issue because how was this filed before the court? Even by the council?
Yes, and that you have to explain now.
My lord, it has to be explained both by the party and by the lawyer. It has to be.
How much time? How much time?
I'm sorry.
How much time?
How much time, my lord? My lord, if lordships direct them to give us a copy, give us 2 weeks after the copy is furnished, we'll file it.
2 weeks.
Yes, my lord. My lord, we'll file our plan. Please go and take.
Yes.
May I submit, my lord, side? My lord, see, after your lordship's order, they filed some reply affidavit dated 27/9/2023. My friend has not. My lords, in this, they rely upon 2007 documents ex facie, my lords. 2007.
So let them explain now. We are asking registry to supply both of you the copies of this report, right?
Yes.
And then he will submit an explanation. Petitioner as well as the council will submit an explanation.
My lords, as
separate affidavit.
my lords,
After 2 weeks.
the property is to be safeguarded in the interest of, my lords, the state government.
My lord, there is an order.
There was, my lords, encroachment. There were constructions, but for your lordship's order on the last date, everyone has gone from there. My lord, this is a fraud on the High Court.
That's why.
It's a very serious thing. My lord, despite this, they filed documents, my lord. There was no state in 2007.
Mr. Advocate General, we are not allowing the petition. We are asking to this thing supply. The action has to be taken against petitioner. So can we do
my
it?
lord, there shall be an my lords, in an identical case, the Honorable Supreme Court yesterday ordered for the registry was directed, the Supreme Court registry was directed to lodge a complaint. Upon, my lords, the identical order was passed as your lordship passed the order.
We will have your right now, Mr. This copy of report. Have you seen it?
No, my lords.
We are directing the registry to supply you copies of these reports. His explanation. He will file. Petitioner will file an affidavit with the light of.
May I request, my lord, since this is a fraud on the court, let it not go beyond, my lords, a week's time.
I want to.
Very serious issue.
Why?
Very serious issue.
I want to make one submission.
High Court order.
He did not oppose. He himself said it's a serious issue. It has to be investigated. He did not. He is not saying that we should brush it aside.
Please don't.
But this, before an action is taken,
I want to make one submission, my lord. I want to make one submission in response to what the learned advocate general says. I agree with my learned friend. That is a serious issue. But I take serious objection to saying it's a fraud. My lord, that is what your elections will
that
say.
we will determine.
Yes.
We will determine that this prima facie.
Position even without looking at the report.
No. So therefore, this let you take a stand. What is?
Yes.
He will also. This
Yes,
thing
my
he
lord.
will also
Yes,
file
yes.
objections to this.
My lord, certain documents are filed here. My lord, 27, some documents are filed. They are also apparently expressive fake.
Let them file a reply. I will not wait.
Well, there was no state of Telangana in 2007. They filed a document that a receipt has been issued. There was no state at all. What else is needed?
So you can file. You point out. Right now we are directing supply of the report.
My lord, I would only request your lordships, my lord, to consider a priority for this case. This type of fraud cannot be allowed.
I agree with my learned friend more.
Of course.
Investigation, my lord, this case demands investigation by, my lords, at least a senior IPS officer. Also that, my lord, that some orders are being put in the court record.
Mr. You are saying that the order, we will pass an order in no moment it will be set aside by Supreme Court. How can we see last date in view of your submission? We have directed registrar division.
Yes, my lord.
Now the report we have just now opened, we have read it in your presence. You don't know what is there in the report. He doesn't know. How can we say that it's a criminal complaint, he should be sent to jail? This can't be. This, without hearing him, how can?
For an investigation only, I will be requesting.
He has submitted fairly that it's a serious issue. It should be investigated upon.
Yes, my lord, certainly.
You file your counter to this.
My lords, I only, once the copies are furnished, I will file.
Yes, yes. That's why we are asking to submit by Tuesday now, because 3 days are holiday. Tuesday, it shall be supplied to both of you. Mr. K. M. Raghavan, Learned Senior Counsel, Mr. B.S. Prasad.
I don't construct, they don't interfere. Maintain.
No, this not to raise any construction. There is already an order status.
Yes, ma'am.
But there should be a direction also that they will not interfere with my position. I will not.
There is already an order.
Yes.
Already.
We are in position.
Interim order granted on 15/2023 shall continue. And status quo with regard to possession.
Yes, bro.
Yes, my lord. We are in position. Yes, my lord.
With regard to possession, as it exists today, with regard to possession shall be maintained by the parties till next date of hearing. List on 13, no?
Yes.
13.
13/10/2020. Yes.
Applies.
So, Mr. Advocate General, he is, you must be knowing him, Mr. Raghavan. He has argued so many cases before me when I was a judge of Karnataka High Court.
My lord, it's a pleasure to have him in this case because he has to also to, my lords, to say, to be fair to the court.
Yes.
But we cannot permit these types of frauds on the court.
No, obviously.
3 orders, my lord. 3 orders on which basis interim orders came to be passed.
That we are taking it with all seriousness.
Yes.
But
Certainly, my lord, no one will support this type.
No, nobody can.
In fact, my lord,
Nobody can.
it would appear prima facie that this order is fake.
All right, let's see.
Yes.
Now you go through the reports.
Applies.
All right. Yes. Now 160. This was 163 to 64. See what he should have said. This copy. Replace it is ready. Last kid. Yes.
But I'd like to prepare for questions. Matter had come up last week. But I
Notice.
now the counterfeit is filed by the contesting respondent, unofficial respondent. I need to file a short reply, or should I have next Friday?
Next Friday. Mark the presence, direct senior counsel for the petitioner, place for short accommodation. Sixth October.
In persons to the orders of this honorable court, Miller, construction permission was granted, Miller, in favor of the petitioner by the GHMC. Miller, as per in persons to the orders of this honorable court, Miller, the construction permission was granted by the GHMC in favor of the petitioner. As per the Miller rules, petitioner has to execute Miller the.
No, so grievance stands redressed, right?
No. Mortgage deed has to be executed, Miller, in favor of GHMC by the petitioner for commencing the construction permission. So now, Miller, in pursuance to the letter issued by the Miller district collector, Miller, the third respondent is not registering the Miller mortgage deed. Agreed by the
respondent is not.
Miller, the
Third respondent is not what?
Registering the Miller mortgage deed
Okay, but in grievance.
in favor of GHMC. Last occasion, your Lord directed Miller to
take service.
Include the GHMC. Blood,
So they have been served?
1 of 23. Blood notice was also served. Proof of service also.
Nobody is appearing GHMC. Who is the standing counsel?
MAK Mukit Miller sir. Served notice on him and as well as on the officials also. Filed proof of service Miller in ESR number 92263 of 23.
That's name of the council.
So will Mr. David take it up next Friday by reflecting his name? Learned counsel for the petitioner submits in compliance of the order dated 15/9/2023.
Please, my lords.
My lord, I appear for the respondent.
Please, my lords, I appear for the immediate petitioner, my lords. My lords, immediate petitioner, senior counsel is appearing, my lords. He is ill with viral fever, my lordship. Senior counsel is appearing for the immediate petitioner, my lordship. He is sick with viral fever, my lordship. I request a 1 week time.
My lord, matter is listed today for final hearing. As well as the last order of the last. No. And the council who is now making a representation has filed a petition for impleadment in the state writ appeal, which is directed in the judgment of the learned single judge. I filed a counter to the implead party petition that the implead petitioner is neither necessary nor proper parties because he was not there before the learned single judge and he cannot expand the scope of this particular intra-court appeal.
Correct, but he is not well. Next Friday.
Right, 2016, my lord, last time the matter underwent adjournment.
Yeah, we are not this thing, we are not adjourning, he's,
Only 1 week, my lord. His past 3 days is seriously.
who is appearing? You are not a party, right?
No, he was not a party.
So your application for impleadment has to be argued.
Yes,
Please, if by next date he is not available, make some alternate arrangement.
With your lordship's permission, may I make a small, same matter, madam? In the writ petition, the society had filed an impleading application, writ petition itself. But the learned single judgment, without noticing that interlocutory application, passed that impugned order, against which the state has comes with an appeal. Person who had filed implead, secretary at that point of time, at present is not a secretary, government has appointed person in charge. Well, the implead petition filed by my friend, the cost itself shows returned by former secretary, which is not permissible. So therefore, when the person in charge has filed an interlocutory application, that is also before your lordship was IA number 2 of 2023.
Well, yes, well, the party seeking to implead is HAL, Cooperative Society. There are two persons, my lord, claiming representative capacity to that particular society. One is the person in charge appointed. It's an internal fight among us themselves, my lord. They want to get impleaded in the state's intra-court appeal.
All right. So, Mr. Whatever it is, next Friday, 6th of October, Learned Counsel for Implead Petitioner prays for accommodation on the ground that arguing counsel is unwell. It is made clear that no further adjournment shall be granted. List on 610.
Obliged. But implead petition IA number 1 of 22. I am
1 of 22.
I am 1 of 23.
All right. 1 of 20. Yes. Yes, madam. Once. What is IA?
I beg to appear.
What is this IA?
Well, on 18th of August, your lordships had.
Yes. Review, right?
Yes, madam.
Recall of.
Now, the count has been filed saying that there is a miscommunication. They was not given impression to recall the review. That's what.
Right.
That.
Mark the presence. This petition has been filed seeking review of the order dated 18/8/2020.
Next week, along with the same batch.
We don't know next week or let it be thereafter.
The earlier matters were 169, almost the same subject matter. That's the reason I was asking for the same. Earlier 169, 170, the same subject matter.
But now this is on merits, right?
Still, it will be part of the same subject matter. I thought it will be easy for your lordship to, the issue will be same. It can be tagged along with similar instance.
These are only proceedings. You say OSA number so and so be listed on 610. That you argue on next date, right?
About the review.
You even if you don't know, you don't say anything, we know what are you going to say. That all cases report should be updated, everything should be adjourned.
In reports are concerned, in respect of CS 14, all properties, report was filed by the receiver, earlier receivers. That was acted upon, final decrees are passed. Only in respect of one property, one item, report is awaited. All reports are passed. I have filed book along with reports.
So let the new report be filed. We'll examine all that aspects.
We're not keeping it safe, we are clear. The list of arbitrators is on my table. List of arbitrators on my table. So I want it, my copy. Get it. Right hand side it's good. Yes. You call madam. Right. Fresh madam. Fresh. Yes. There is it is coming up for the first time. Ah, record perused. We should note it.
My lord, I'm appearing for the applicant in this matter, 195 through online mode.
Lords, I appear with the petitioner in this matter. 196 and 198 go together, my lords. It's a fresh application.
196 and 198. Issue notice.
My lords may permit us to take on personal loan.
Personal, whatever. Huh? Both the cases, personal, this things, proof of service.
May I please your lordship? I appear for the petitioner before your lordships, my lord. It's a fresh matter, my lords. Personal notice may be permitted, my lords.
Same matter.
Oblige, my lords.
Item 199, case in back to maximum.
May it please your lordship. The present I have tried to reopen the arbitration application, your lord.
Right.
Arbitration application was filed way back in 2013, your lordship, and it was dispatched, your lordship, for 14/9/2018, your lordship. The applicant herein has approved the Honorable Supreme Court by SLP number 5/490. It's on paragraph 3 of my application. The order copy is next from page number 17.
2 months from today.
So, page number 8, Your Lordship.
1 minute.
Proceed to pass an order appointing an architect as early as possible, preferably within 2 months. The order was passed
Sorry.
very much before the
Madam, 1 minute. This, you keep it in that petition. Yes. Just now records of the division bench. In that file. Where is it, madam? List of our list. You go and bring it. List is, you understand, right hand side skipped. He will not be able to. So you tell us the name.
Permission, my lord. It matter. ML Narsimham, representing for ML Narsimham. I am representing for the respondent council ML Narsimham.
This is all Mr. Concluded. Right? No adjournment. This is the order of Supreme Court. It binds everyone. Article 141. This you have made a submission before Supreme Court that the dispute between the parties can be resolved by arbitration, and this thing you may be permitted to raise all objections under section 16. This is what it is, Mr. How can you then again file objections, keep it pending for 5 more years? This is not a civil suit. We are not granting you adjournment. We will appoint a former. What is this thing dispute, Mr. How much?
I am not aware of the dispute, Your Lordship. Which contains the arbitration clause is dated 4/8/2007, Your Lordship. The order copy dismissing my application is carried at page number 10, Your Lordship.
What is the dispute? What is the dispute? About what, Mr.? That also you don't know.
This is relating to 7.5 megawatts biomass power generating unit located at Chhattisgarh.
Venue of arbitration is Hyderabad.
Lordship may take it up next week, Your Honor.
No, nothing. The Supreme Court has directed us to decide it within 2 months. Same applies to you also. What is it? Why next month? Nothing. We are appointing a former judge of this court. What, Mr. 11-6, you people keep seeking adjournment. What is